G'day everyone, and welcome to what is a special little additional video, I suppose, or an amendment based on last year's exam. A little bit of an update to, I suppose, the skill and what we need to do with the key responsibilities or the responsibilities of key personnel. So I wanted to make this quick video to go with the one that's already out there that goes through those responsibilities in a bit more detail. It's the same quote on here, but it is one of my favourites, even though it is an unknown one and probably made up somewhere along the line. And that's just the idea that if you want something you've never had, then you've got to do something you've never done. And again, it's so key in Year 12 that when you're not getting those results that you want sometimes, too often we see kids just continue to do the same thing and not adjust anything. And it's that idea that, hey, you're going to have to try new things and new ways of getting through a new revision strategy sometimes, and keep asking for support with those, because that's what's going to get you those results that you really want. Look, as I said, this is a little bit of an additional video and just an amendment to the original one on 3.1.9, which is the responsibilities of key personnel in a criminal trial. And what I really want to focus on is this skill, 3.1.7, and what is actually meant by the term discuss. Because we had an exam question last year that required a discussion around the responsibilities of key personnel. And if I had the video on right now, you'd see me with the hand in the air saying, absolutely hands up here. I got this skill wrong in the first video, and what we need to do is actually slightly different to what the first video says. So we'll jump into it. Again, these are the people we need to know the responsibilities of, and I'm not going to go through these in any detail. You can watch the other video. This stuff is still true and correct in terms of those responsibilities. It is worth noting that the language or the questions that we've had over the last few years of this have always been very specific about, say, explain one responsibility, for example, rather than just being about, overall what are the responsibilities of the judge. It's very clearly wanted us to be able to pick out individual things that these key personnel do. So, for example, one responsibility of the judge is to direct the jury or instruct the jury. And this could include instructing them on what the meaning of beyond reasonable doubt as a standard of proof is. For legal practitioners, it can be as specific as they have to provide an opening address. They cross-examine witnesses or they question witnesses. So being really specific or being able to break down the responsibilities of each key personnel into very almost specific tasks that they do is what the exams wanted us to do. But as I said, the big one here is I want to focus on this term discuss. Now, discussion, as we know, and I say this in the other video, is always about an exchange of opinions. So it's always about trying to find the other side or the two sides of something. And what I said in the previous video, what I thought this skill would be case study based, and it would be more or less being able to work through a case and talk about what things the key personnel do, but then also having that understanding of what they don't do. So, being able to understand that a judge is the legal expert, instructs the jury, ensures a fair trial, but that as part of that, they don't assist parties, particularly unrepresented parties. And actually having that ability to look at a case study and be able to go, okay, I know that in this situation, the barrister's going to do this, but not do this. The reality is, based off last year's exam, and I'll show you the question in a moment, that's not what we're meant to do. And a discussion is something that's a little bit more, I suppose, nuanced than that, and a little bit, I suppose, less clear in terms of what the two clear sides are. So this is the stuff that's in the previous video that you can look at. What do they do? What do they don't do? But the question I'm talking about from last year is this one. So the case scenario, 23-mark case scenario, I actually say in the other video that I think these questions will come up in longer case studies, 20 to 30 marks. So I did at least get that part right. This case study talks about Guy being the victim of an attack by Tom. He suffers significant injuries, fractured eye socket, etc., etc. Tom pleads guilty and goes to prison for 4 years. Guy is also considering suing Tom to basically try and get some of the money he spent on medical procedures and such back. So it's a bit of a question where it's like there's going to be some questions on the criminal side of things and the civil side of things. And we got this question C that is based on the civil responsibilities, but it does cross over into what we need to know for criminal. So the question was, assuming Guy's case proceeds to trial, discuss the responsibilities of both parties involved in this case. Now, the old approach would have been, okay, again, it's civil, but if we just look at the criminal parties, the old approach would have been, okay, talking about how the prosecution has to prove beyond reasonable doubt, whereas, the defence doesn't have to, etc. That little bit of what they do and what they don't do. What has actually since come out, and this will be in the examiner's report, is that the discussion here is absolutely first and foremost knowing what they do, so knowing the responsibilities. But the other side of it, when you're doing the discussion, it's expected that you are starting to consider and analyse the limitations of this. So limitations or restrictions or even negatives. So as a result of these responsibilities that the parties hold in this case, what are the negatives that come with that? What are the limitations that come with that? What issues, in a way, does that cause for our legal system? That's what the discussion's about. Not what they don't do, but actually, okay, what issues does this responsibility cause for our legal system? And again, the question was on a civil matter, but that means the skill's the same. It means this discussion is going to be the same if it comes up on a criminal matter. So what I've done here is, again, considered each of their responsibilities and then looked at what a limitation of this is, or what an issue that could arise from these responsibilities are. So one that I've already mentioned, for example, is we know that the judge is responsible for instructing the jury, applying those rules of evidence and procedure, resolves any points of law, more or less as an overarching role ensures a fair trial, and those responsibilities are part of that. But rather than being like, well, what don't they do, what issues does this throw up? And this is often really closely linked to the principles of justice. Well, one of the big issues that these responsibilities of the judge throws up is that despite being legal experts, judges are actually unable to assist parties, particularly unrepresented ones. And we know that if a party's unrepresented, can't put forward the best arguments, the judge can't help them, that this is potentially a negative outcome for fairness. So we're often actually saying, okay, based on the responsibilities of these key parties, what issues does this cause? What negatives does this cause in relation to the principles of justice? So if we look at the jury, and this is a really common one that we've been over thousands of times, it comes up quite a lot with rights of the accused person. We know the jury decides questions of facts first and foremost. Based on the questions of facts, they deliberate them, they take instructions from the judge, and then they deliver a verdict. What are the limitations of this? What are the issues with this? Well, the big one is we know juries are not legal experts. It means they may make a decision that has some bias or prejudice in it, and we know that this probably really closely links to fairness as a principle of justice. Now, the other one that you could potentially consider here is that a limitation of a jury is it adds time to a case. And what principle of justice does time link to? We know that that's really a negative for access. So we're starting to see that, hey, based on the responsibilities of these key personnel, what issues does it cause as a result of being set up in this way? The barrister, and it's really the same for the solicitor here, a barrister specifically examines witnesses and cross-examines the opposition's witnesses. They deliver the arguments to the jury, often through opening and closing addresses. Basically, that legal strategy side of things in the courtroom, coming up with what to say and the right time to say it, what question to ask, the right question to ask. Again, always the issue with legal representation is that without it, you're pretty much cooked. It's really hard to represent yourself, but having it is expensive, and particularly good representation. And we know that daily fees for barristers can easily climb into the $1,000 plus range. Average length of a civil trial, as of a few years ago, was 8 sitting days. So very, very expensive undertaking. You need one to deliver these arguments for you. You need one for your trial to basically be fair. But what does that, or where does that end up in terms of access? The expenses that come with it in defending yourself. But then also, if you can't afford it, where are the issues with fairness? And one of the big things in this case study that you could have picked up was Guy's responsible for getting his own legal representation, but he can't afford it. So what are the limitations? Well, it's expensive. If he can't afford it, he might not actually get fairness because he might not be able to pursue his case properly. Solicitor, same deal. Slightly different roles in terms of briefing the barrister, preparing any required briefs for courts, so on and so forth. But the limitation or issue with this is you need it. And we should actually say that really you need it. And because you need it, the expense becomes a concern. Lots of ongoing fees for all work linked to the case. We know they charge out often in 6-minute blocks. So be it every phone call that they take with you, every meeting they have, every brief they have to prepare, every time they have to respond to something from the courts, so on and so forth. That all adds up. It's an ongoing fee and you need it, but it's expensive. And what does that do in terms of access? Also fairness. And we know that there's links there to equality as well, because when we get to the parties in a criminal matter, the prosecution, really they are lawyers, so the prosecution carries the same responsibilities as barrister and solicitor. There's teams there. But their main responsibility is to prove beyond reasonable doubt that you committed an offence. The limitation of this is that you basically, both parties aren't on equal footing. So the prosecution is government lawyers. They are trained legal experts. The government has no issues pursuing a case against you, really, no limitations in terms of money, etc. Whereas for an untrained individual, you need that representation. You automatically start on an unequal footing because ultimately you have the responsibility of preparing your own defence. So you have that responsibility of finding your own legal representation. You have the responsibility of deciding what you will and will not admit, what facts you will agree to. And as a result, in the first instance, you aren't on equal footing with the prosecution unless you get yourself a lawyer. And we know getting yourself a lawyer is expensive. So again, considering what the defence has to do is they have to prepare their own arguments. They have to prepare their own legal strategy. And to do that, what are the limitations? Or the fact they have to do that, what are the limitations? They're on unequal footing with the prosecution unless they get representation. If they get representation, it costs money. There's issues there with access, fairness, equality, all of those things come forward. I would just point out really clearly, like when we talk about the defence having the responsibility of, deciding what they will and will not admit, what facts they'll agree to, etc. This is a big part of criminal matters. It's not always every single fact of the matter is disputed. There's lots of pre-trial back and forth through the committal stage and then otherwise around, okay, what is the defence actually happy to agree to, so that it doesn't have to be disputed in court. It can just be given to the jury as a set of facts. So, for example, my class and I observed a murder trial in the Supreme Court a couple of years ago, and we were lucky enough to have the defence barrister come and talk to us, and he was able to explain that pre-trial, the prosecution and the defence had been able to agree that the accused person had, in fact, killed the victim. That was not a fact that they were going to argue at trial. It was going to be presented to the jury as a fact that the accused person did kill or cause the death of the victim. And they said, we're not going to waste days at trial trying to establish that. We're just going to admit to that fact. What we're going to argue, though, is whether he intended to, which is often the case in murder trials. So, again, that's that whole bit more nuance there, but the defence has that full responsibility over and control over their own defence and has to decide what facts they are going to admit. And obviously they work with usually a legal team to do this, and what are the limitations that come with that. Again, there's principles of justice, and we've just talked about a lot of them there, and you can watch the other video to go through that in a bit more detail. As I said, make sure you watch this in conjunction with the original video. Just put aside that original talk about the skills going to be what they do and what they don't do. That's wrong. I absolutely got that wrong. A new study design is a bit of a guessing game, and that's the beauty of past exams and making sure you look at them, and particularly the examination reports, is that gives you the absolute definitive guide to what you do have to know and what you do have to do and what you don't have to know and what you don't have to do. Based on the study design. And we know for a fact now that a discussion is what they do and then the limitations or issues that presents, as opposed to what they do and what they don't do. So hopefully this has been really helpful. First little additional video for the year. If you have any ideas for anything else or have any, I suppose, things that you want clarified, let me know. We will do a full new video for this dot point in 3.2, so the civil version of this dot point. We'll do actually a complete overhaul before that starts, just to remove that old misconception. As I said, reach out if anything's unclear, but happy studying, and happy 2021.